All right, thanks. Good afternoon. I'm Hal Singer. I'm the director of the Utah Project. And this session will explore Guideline 11, when a merger involves competing buyers and the implication for workers. Whereas some defenders of the status quo, including a former FTC commissioner, might call the Communist panel. I'm warning, there are some bad jokes in here. I'll note, because we are also proficient at doing Control F inside of this document, that there are 23 mentions of the word workers in the draft merger guidelines, 23. By comparison, there is no mention of workers in the 2010 merger guidelines. Now, talk about a change in values. Consumers no longer sit alone atop the antitrust hierarchy. Now, I know a thing or two about trying to apply antitrust to labor markets, enough to be dangerous. Just quickly, by way of background, I'm the expert for workers in at least 4 cases, including the UFC, a class of workers that just got certified, a class of McDonald's workers, chicken growers, and then finally a no poach case that I have not yet been disclosed in. But that's enough. I feel like this is so hard that I'm ready to pass the baton off to the next generation. I'm ready just for an easy price fixing case to come along. But today we're actually going to hear from an esteemed panel of antitrust scholars, each of whom researches the labor markets. And a very quick intro for each is in order. Ioana Marinescu is the principal economist of the DOJ. She is also an associate professor at the University of Pennsylvania School of Social Policy and Practice. Eric Posner is a professor at the University of Chicago Law School, and he is the author of How Antitrust Failed Workers from Oxford Press in 2021. Nancy Rose is a professor and the head of Department of Economics at Massachusetts Institute of Technology. You've been introduced to Nancy already today, and she has graciously taken in for Theodosia, who fell ill, and I hope she's doing better and watching this from home, and we're going to have her out at the next conference. Finally, Aaron Sojourner is a labor economist and senior researcher at the W.E. Upjohn Institute of Employment Research. Prior to that, he worked at the University of Minnesota's Carlson School of Management. He took leave for the 2016-17 academic year to serve as senior economist for labor at the U.S. President's Council of Economic Advisors. So there's your panel. I think we've done a pretty nice job gathering some of the biggest names in this area. Now, following the formatting of other panels, we're going to kick off with Ioana, providing a brief justification of why an entire section on worker harms was even necessary, particularly when, 1, defenders of the status quo claim that consumer welfare really means trading partner welfare, which would include workers, and 2, the DOJ successfully stopped a merger among book publishers under a theory of harm to writers. So Ioana, why mess with something, in this case, merger enforcement to protect workers, when it's working so well?
Well, I mean, I think we really wanted to clarify a number of points here. And, just as you mentioned, the number of times that the word workers appear, you will note if you look at the publicly available speeches by Jonathan Cantor, our boss at the Antitrust Division, that it's now a formula to say competition for consumers and workers. In many cases. So, I invite you to check that out. So there has been a movement there. And you also mentioned that, we have to think about the fact that the merger guidelines are a statement of the agency's enforcement policies. And so they reflect what we are doing. And one of the big things we have done is indeed bring up this merger challenge to Penguin and Simon & Schuster, which were 2 major editors who wanted to merge. And we argued that the merger would reduce compensation to authors. And the judge, took our side, and the merger was blocked, and the parties decided not to appeal, which I think was a very significant victory for the DOJ, because this was the first time that we prevailed on a monopsony case theory involving work alone. And so the merger guidelines, the draft merger guidelines come in this context. And, they recognize that mergers can decrease competition for labor and also, frankly, increase the risk of employer collusion. So, following up on what we discussed this morning about the importance of considering coordinated effects, this should also be considered in the labor context. So the consideration of buyer power actually has a long history in the merger guidelines. So since 1982 already, the merger guidelines were considering competition among buyers and employers or a specific type of buyers. They are vying to buy labor services. And so, monopsony in that sense is a mirror of monopoly, where in product markets, you have competition among sellers to attract buyers. And in the labor market, you have competition among employers to attract workers. And so, this was also discussed, by the way, all the way through the 2010 merger guidelines, this issue of monopsony. We just, elaborate on this point. So why and how do we elaborate on this point? First, we wanted to reflect the learnings from economics that show that labor markets have certain specific characteristics that can make them especially narrow, including high switching costs, search frictions, and right now I'm working on a number of literature reviews that make all these points much more explicit, and our textbook chapters as well for students to better understand those points. And then secondly, we also wanted to clarify, and this is very much consistent with our recent case in the publisher case, that agencies are going to evaluate the impact of mergers on labor as a standalone basis. That means if there's an issue in the labor market, that is a sufficient condition for us to go after this merger. We need go no further. So that's an important point of clarification. And then let me say two more technical points. First is that some commentators were not clear that the rebuttal section applies to labor markets. It does. So the whole thing that we say about rebutting the merger applies to labor markets as well. And so, the parties can always argue that, in fact, the transaction does not harm competition in the labor market. But it has to be a within labor market argument. So they have to be able to counter argue that, for XYZ reason, in fact, workers are not going to suffer from a decrease in competition in the labor market. And finally, I want to note that in terms of the economics, we have for labor markets the exact same set of tools that we use for product markets. So the whole appendix that we talked about earlier, it completely applies to labor markets. And we even mentioned some specific examples. That's why we see the word workers in a number of cases in terms of, for example, the hypothetical monopolist test becomes a hypothetical monopsonist test when you apply it to the labor market. But the reasoning is very much the same as in the case of product markets. So we have all of these classic tools that you can apply to labor markets. And so in that sense, this section, similarly to the platform section, is an application section where all of the tools that we talk about in the merger guidelines are applied to a particular case, but it is a very special and important case that we wanted to make sure that is getting mentioned in the merger guidelines, given again all the recent research that we've seen in this area. Thanks.
Great. Before I move on to a question for Eric, does anyone want to respond to anything that Ioana had to say, or should I just keep flying through? All right. Well, let me try this, Eric. I know that you were one of the authors of the draft guidelines, but I presume you weren't able to impose 100% of your preferences on the final product, despite your amazing superpowers. Do you have any criticisms of the merger guidelines as they apply to labor markets? And how would you perfect this draft if you held the pen?
Well, no, I don't have any criticisms of the merger guidelines. I think they're perfect. But let me raise some questions about the guidelines for labor. So one thing that maybe some people might raise questions about is that what the guidelines obviously do is they take the HHI thresholds that are used for product markets, the new ones, basically 1800, and apply them to labor markets. And you might ask, well, should they be the same thresholds? There are a lot of differences between product markets and labor markets. And Is it just a happy coincidence that the thresholds are the same, or does that reflect something about the world? Um, uh, the Now the HHI thresholds themselves are to some extent throughout the history of the merger guidelines somewhat arbitrary. You know, they're basically determined pragmatically and reflect the intuitions of enforcers over the years. And the reduction in the merger guidelines from to 1800 reflects a strong view, I think a very widespread view that the merger guidelines have been under enforced. But again, the experience is with product markets, not with labor markets. So so this raises the question how these thresholds should be determined in the first place. And I had an exchange with Nancy about this briefly during her panel. And there are some attempts by economists to just calculate, you know, what the optimal HHI threshold should be. And this is a kind of a very kind of crude, but I think important project. So there's a paper by, I think it's Notke and Winston in AER, which does this for product markets. And they find there are complications, but they find that HHI threshold should really be pretty low. That is pretty strict using their model and their data. And so I've collaborated with a bunch of guys to try to do something similar for labor markets. And this is what I wanted to talk about a bit. And this is after my term in the Justice Department. So my collaborators are Berger, Herkenhoff, and Manji, along with a fourth guy, Thomas Hasensegel, at the University of Minnesota. Berger's at Duke, I guess, and Simon is now at the Fed. So Berger, Herkenhoff, and Manji have a model of labor markets, which I think has been, you know, very influential or has gotten a lot of attention because it solves a lot of problems of how one should go about modeling labor markets, including market definition and so forth. And one interesting aspect of the model, which is relevant to, I think, issues that will come up about consumer welfare and so forth, is that it's a general equilibrium model. And so the workers are also consumers. So basically households either consume goods produced by firms and they contribute workers who are paid by the firms. And so in their earlier work, you know, they developed this model and they test it in various ways. And in this paper that I'm helping them with, they're just taking this paper and then they're saying, okay, well, what happens if the firms merge? And then you can kind of come up with HHI thresholds after making an assumption about what the efficiency gains are from a merger. As Nancy has written, and this was discussed earlier, the efficiency gains from mergers appear to be pretty low. We assume 5%, which is very much on a high level, but you know, one can adjust that. And then what you do is you just do simulations and you imagine mergers, firms merging in lots of ways. And so just two quick conclusions from this exercise. And if you're interested in reading the paper, it's a draft that's I guess with NBER and it's posted, or you could just email me and I'd be happy to send you a link. So good news is the paper shows that there's definitely a welfare improvement for reducing HHI thresholds from 2,500 to 1,800. You'll be pleased to hear. So people should be better off generally. Workers should be better off generally if you have this stricter threshold. And then the second point is that actually the HHI threshold should be still stricter than that. Yeah. So if you want a criticism, this paper, the methods that it introduces and the data that it uses provides an argument that the HHI threshold should be even lower for labor markets. We don't take any position on what they should be for product markets.
Well, that's fantastic. We have a criticism of the Biden guidelines from the left, and I'm just curious: do we have a unanimity on that point across the panel, or any pushback? I'm sold. I think that the threshold ought to be lower for for labor markets, of course, relative to product markets in light of the special characteristics that Ioana mentioned, specialized skills and all the like. Are you okay with that, Nancy?
I don't exactly understand when you say in light of specialized skills and all of that, right?
Sure.
So it sounds to me like what we're saying is maybe there's a product discrimination market. And in that case, like I think the way we approach that in product markets is to say, are there particular groups of customers who are likely to be disadvantaged by a merger? And we'll consider that group of customers. So if there are some employees that are similarly particularly likely to be disadvantaged, I don't know that that implies a different HHI as much as a different analysis of that kind of discrimination.
I think the claim though is that a monopsonist wouldn't have to control the same size of the market in order to exercise buying power over workers as a seller would in a product market. So there was a judge, won't mention his name, who said that a fast food company could not wield buying power over its workers in light of the fact that it controlled something like 5% of the employees in the fast food industry, right? So I'm just curious, would that move the needle or change your mind, make you any more sympathetic?
Yeah, I don't know. I guess my sense is while we're uncertain about the right level for HHIs in product markets, and I actually think the Noki-Winston paper is more about the delta HHI needing more attention. It's really, in fact, what they say is the level is not that dispositive about the likely harm from the merger. It's really the delta. I guess I feel as though, and I haven't read your paper yet, so I'll put that on my to-do list. I guess I feel like our understanding or even intuition of how this works in labor markets is sufficiently underdeveloped at this point that I'd be reluctant to endorse a particular deviation until we kind of build up more of our sense of how it matters. But again, that's just about a structural presumption. That's not about if we can demonstrate harms in a particular labor market that you can't go after it, even if it's, doesn't hit those target levels.
If I can just add a little bit more. My intuition was exactly the same as yours is when I was working on the guidelines, which is, we don't know very much, so we should just use the same HHI thresholds as they're used for the product market. My instinct is that switching costs are much higher for employees than for customers, and so to take the example of fast food, the franchise case. So this is the McDonald's case, and the Court of Appeals for the Seventh Circuit in a case which is, in many ways sympathetic to the plaintiff's claim, do start out by saying, basically, and I think a lot of economists kind of think this way. A fast food worker, what do? They don't have any skills. So if McDonald's fires you or lowers your wage a little bit, you'll just go and work for Wendy's, or you could go work for Home Depot, or you could go work for work in a warehouse. You could work for any number of employers, because by definition, if you don't have any skills, you're just being paid for doing some task. And there are going to be all kinds of employers out there. This is Chicago, so this is downtown Chicago. All kinds of employers out there who will hire you, and so that means that McDonald's itself, the McDonald's franchisees, of which there are maybe dozens in downtown Chicago, collectively aren't going to have market power over these people. And this was in response to an argument made by the plaintiffs that McDonald's itself had market power over the workers. But I don't actually think that's true. Now, this is not based on my own experience, but I think there's at least an argument that if you've been working at McDonald's for a bunch of years, you've developed McDonald's specific skills. You've been working with a bunch of people who you know and you've become friends with, and you have a certain area in which you're willing to commute. You probably don't drive, probably where the subway line or the bus line matters a lot to you. And so it is an empirical question how this market should be defined, but it's wrong for a court just to say a case which claims that the labor market is just McDonald's workers is just implausible, right? And we're not going to allow you to make the empirical argument that there's actually a very narrow labor market here as a result of the high switching. So that's the
But
kind
that's
of
very different than what the HHI should be. That's where I was saying, I think of it more as a kind of price discrimination analog, in the sense that what you're saying is that in fact, the degree of substitutability from McDonald's work to other employers, even in fast food, is not high. And I don't think we have a problem like bringing those types of challenges. I think of, there were paper mill mergers when I was at DOJ where the concern was, a local mill might have a lot of control, a lot of market power over customers close to that mill. And so if you merge two close by, you'd affect those even if you didn't have an effect on the national market. It wasn't about HHIs, it was about.
But it's still,
So
if there's only, if switching costs or search costs are high for a given number of competitors, it will be harder for employees to discover and switch among them if your wage goes up than it would be for an analogous consumer who's facing multiple sellers.
If I can just jump in about analogous, I think this is critical, and I think that would be helpful in academic work on this topic, which I think we need to, just as usual, build up the academic work. It's, are we comparing apple to oranges, at least within a paper? Because when we're saying labor markets should have higher HHIs, and this is no comment on whether they should or not, this is like a comment about how to present it. Are we really comparing with what sort of product markets though? So I think that would be interesting to ask, like, what is the characteristic within that academic paper that we're writing of labor markets that makes them call for potentially a lower HHI. So in that sense, I think the analogy is important. The second thing I wanted to briefly mention is that a lot of people have the intuition that so-called low-skill labor markets are very competitive because it's so easy for a worker, like, Eric was saying, to just substitute to any job. But, the empirical evidence that's building up in this literature, including my own work, is that doesn't seem to be the case. So, we, for example, in my paper with Jose Azar and Steve Berry, we look at the hypothetical monopsonist kind of test, and we show that, it doesn't, the elasticity essentially of labor supply to the market, and therefore market power, doesn't vary systematically by skill. So it's not the case that if you look at quote unquote lower skill labor markets, candidate labor markets, you always find that elasticity is higher, which would mean there's less market power, because you know what? The worker could go somewhere else if they were getting underpaid. And so I think in every case, it's going to be a fact-specific inquiry as well of asking, for that particular type of worker. But certainly in general, I would say the literature doesn't support the idea that we can just make the assumption that obviously, the low-skill labor markets are going to be more competitive. We really have to look into it.
Can we get Aaron involved? What do you have to say about the difference between product markets and labor markets? Why are workers so special?
Let me just throw out one piece before I get to that, which is that there's a nice paper by Evan Rose, I don't know if he's any relation, and Yemtov that looks at how replaceable is a low wage job, and finds that, if you lose if a low wage worker loses their job, they suffer a lot of harm. And it's really hard to get a new job. They lose earnings, they lose wages in their next job, and they suffer a pretty long period of unemployment. And it's worse than for like a middle skill job. So a middle wage job. So yeah, I think this is like an easy assumption to make. It has a lot of face validity and plausibility to people who aren't low wage workers, but it is wrong, and it shouldn't be used to make important decisions. And there's a lot of evidence that Ioana was talking about that, yeah, that it's wrong. So in terms of how do product markets and labor markets differ, I'll just, a labor market is somebody buying and selling sort of labor services, doing a set of tasks under a particular set of conditions at a place at a time, in a given environment that's sort of dictated by the production process. And the employer wants people to show up and do that work, do those tasks at that time in that place. And, workers have to accept that responsibility. And, they're bargaining over rights. And it's a very complicated market. Eric and Suresh Naidu, as a professor at Columbia, have a very nice paper where they articulate this very well about how the labor market is doubly differentiated. Buying gas at the corner, like it's a commodity. The buyer doesn't care who they're buying from. The seller doesn't care who they're selling to. It's, neither side really cares. It's just money on the barrel, pump the gas. A lot of product markets are differentiated on one side, but again, the seller doesn't care that much in a lot of cases about the buyer's identity. And the products are pretty simple. An iPhone, it's complicated, but it's not as complicated as a job. A job has a lot of dimensions. We tend to focus on the wage because it's easy to measure. It's a big dollar thing, but flexibility, ability to take time and deal with family situations, occupational safety and health risks, who are your coworkers, it's how your boss treats you, how your supervisor treats you. Like it's a really complicated object, and it's very hard for workers to assess quality from the outside. So it's really an experience good. You can't judge its nature from the outside. You only really learn what a job is like once you get inside. So that keeps workers frozen in place to some extent. They're scared to take a risk and make a jump. So this also diminishes substitutability between jobs and creates market power for employers. I don't know. That's my answer to your question.
All right, we're going to move on. And I heard Ioana say something in her opening, and I hope I'm being faithful to this, but basically it's that if you can show a harm to workers in the input market, that should be sufficient to trigger an investigation, even prosecution, right? But I want to put on my Herb Hovenkamp hat. I think I'm channeling him where he would say, no, I also demand that an effect in the output market. So I want to try this tough question for Nancy, but it's open really for anyone. And I want to ask, is it really a good thing to block a merger that hurts workers if that merger would also help consumers? I just want you to consider this hypothetical. Two factories merge and are able to reduce wages. Isn't it a good thing when mergers result in lower labor costs to the extent it could mean lower prices for consumers? Isn't that a good thing for the economy? Why make things so complicated? I'm wearing my devil's advocate hat here. Of course, this is not me speaking. Why make things so complicated by telling the agencies to look at labor markets as well as product markets?
Yeah. So to your first question, which I think is that a bad thing? Absolutely. That kind of merger is a terrible thing. And I don't even think we need kind of modern antitrust to reach that conclusion. When I came out of the administration of the DOJ at the end of 2016, there were two things that had frustrated me about how we thought about not just labor markets, but all upstream markets, and at least part of this applies to all upstream markets, right? So one was that, in fact, the agencies had often brought challenges based on upstream harm, but they really didn't want to litigate them. And so we had a lot of settled mergers that involved upstream harm to nurses or to farmers. But at least in some cases, that investigations that I was part of, where there might be a merger that was going to affect both upstream suppliers adversely and downstream buyers adversely, the lawyers would say, well, let's just focus on that downstream because that's very straightforward. So one thing to know is that while there were no litigated upstream harm cases, it didn't mean that everything that was a problem for upstream, what we were just deciding to let go. If you had harm on both sides, and it was a lot easier, you thought, to bring the case on the downstream side, And since all we have to do in mergers is find harm in one market, why not just bring the downstream case? So where does it get a little bit more complicated? So let me hold your efficiencies example for 1 minute and just pitch why I think it is important that we've continued to elaborate this upstream harm, and particularly for workers in the new guidelines. So first is that there might not be any harm in a downstream market. The harm might just be in an upstream market, or that the product market where you think the firms are engaged in doesn't involve a diminution of competition. So for example, hospitals and skilled nursing facilities, right? If they're in the same kind of labor market area, that merger may adversely affect competition for, say, RNs, registered nurses, and not pose a particular problem for product market, right? And so if we aren't thinking about upstream harm, we're going to miss that nexus of harm, right? A second is that when we're thinking about divestitures, if we're not thinking about the labor market and the upstream markets, then we might allow companies to decide, and we want them to divest some part of their assets because of downstream harm. We might allow them to structure those divestitures in a way that gives them the power to exercise market power against suppliers, including workers. And we ought to be thinking about that in evaluating proposed settlements. And then the third is, and I think this isn't, I wouldn't say this is the reason, obviously I don't know the reason, I wasn't inside, that the publisher's case was brought, but I think was certainly an advantage of the publisher's cases. I think that was something where, as I was looking at that case, I expected there would be harm in downstream markets, there would be harm in upstream markets, not just for these best-selling authors, but that the best-selling author's case was perhaps the crispest to bring. And so sometimes we're going to want to bring the upstream harm case because, that's the most persuasive before an advocate. So now we get to this complication that you pose. Suppose that we think there's downstream benefits. So there's an upstream harm and the companies come in and argue, oh, but they're going to get passed through and that's going to lower prices. Well, we have a case like that. Anthem Cigna was a case where Anthem came in and said, when these two health insurers merge, we're going to be able to reduce the cost of healthcare. What did that mean? We're reducing payments to providers upstream, and that's a big efficiency. And so I was very excited because we finally had a litigated merger complaint that had an upstream harm allegation in it. I think it was the first charge in the Anthem Cigna complaint. And then we kind of backed off it in litigation. I think we thought we had a very strong downstream case and they could neutralize the efficiencies. And so they didn't pursue this. But the judge was asked to make the kind of determination that you've asked. And the parties came and said, Your Honor, this is going to have such huge benefits downstream. And there's all this market power upstream. So you should like us merging to kind of defeat some of that market power. So it wasn't even just a pure cost savings going downstream. It was even better. We're going to make it more competitive because we're going to have offsetting leverage. And the judge said, it cannot be the role of a federal district court judge to decide the optimal configuration of the United States health insurance market. That's a job for Congress. I just have to find, does this merger reduce competition, or is this merger likely to reduce competition in any relevant market? And so that's a very long way of answering your question to say, if it reduces competition upstream, we're done. And you don't get to say, what is it? The lawyers will tell me, fruits of the poison vine or something. There's some great, Scott Hempel's got a great tree, got a great cite to that in our paper on upstream harm. You don't get to say, oh, but somebody else might benefit from this illegal act that we performed.
Well, you're preaching to the choir, Nancy, but does anybody have any objections? Or we have, objection?
No, not an objection,
Okay.
a reinforcement.
Okay.
Also, I want to say that the basic model that we usually, like to use, the oligopsony model, would predict that typically there will be, in fact, a harm to consumers if there's a harm to workers, typically, again. And why? So the reason is when two companies merge and they thereby gain market power over workers and suppress wages, they also employ fewer workers. It's the usual reduction in quantities. That reduction in the number of workers that are being employed will lead to a reduction in output because you're going to produce less. and all other things equal, that's going to increase prices for consumers. So of course, this is a model, but that's the typical, case that you would think about. So in principle, there should be that effect. Now, it is also true we don't need to show that. In fact, it's enough that there's harm for the labor market, period. But I just want to note that as a context that, you would typically expect to also see some harm on the consumer side.
Can I
Eric?
just say,
Oh.
even without the output, Scott and I argue, even without the output reduction upstream, if you just reduce wages because of, say, leverage, that's an anti-competitive harm that's actionable.
Take that.
Oh, yeah.
Eric wanted to weigh
Yeah,
in.
yeah, I mean, just to add to that, I mean, this is in some ways, some people might still be unsatisfied thinking that the court should do some kind of overall welfare assessment. But just to be clear, this has never been the case in merger analysis or antitrust law. And so in some ways, this is just a very old issue. You could have a merger that affects two different product markets. Just imagine a merger of chain stores, for example. And in one product market, consumers are benefited, and the other they're hurt. And the traditional, the law has always been, you block that merger. Now there may be a way to have a remedy, divestiture of one of the stores, but that, so you can just think of the upstream market as akin to the second product market. And the rule is, if a merger substantially lessens competition in any market, it's illegal. So it could be one of a number of product markets, one of a number of upstream markets. It doesn't matter. And I think the conventional wisdom, the reason for this is that it's too difficult. And this is what Nancy was saying that the judge said in the Humana case. It's just too difficult for courts to do some kind of welfare balancing across markets, which is what the Supreme Court has said in earlier merger cases as well.
I would say, sorry, it's not just welfare balancing, but it's also the in economics, we like this general equilibrium approach. So, you could say as an economist, let's calculate the total welfare impact. And then we have to calculate, cross-market effects, because usually when a product changes prices, it affects suppliers, yada, 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 and the whole economy ultimately. But, we don't want to ask the judge to engage into that sort of analysis. It's just not administrable. So
I don't mean to rain on the parade, but I would be remiss not bringing up the NCAA cases. Ted, my co-authors in the audience, where the courts have for decades tolerated a wage fixing conspiracy that clearly harmed college athletes because of some offsetting benefit to viewers with a taste for exploitation. Oh, I meant to say amateurism. Amateurism. Damn it. Sorry. All right. Just had to get that out there. Well, let's bring Aaron into the mix. We'll fix the NCAA problem on the next panel. We seem to be in a striking pandemic, Aaron, where one strike begets another. And Americans are largely supportive of unions, more so than ever, and even their strikes. So I have a hypothetical for you, and I get to do this to you because you're an economist. If workers are unionized in the case of a merger, should we still be concerned about the merger's impacts on workers?
Yeah, absolutely, we should. The fundamental concern is employer market power and diminished competition for labor. And as Ioana just articulated too, like in this kind of situation, you'd expect the merged employer to have, stronger incentives to underemploy, to underpay, to underproduce. And again, there's a big literature in labor now that employers have a pretty substantial degree of market power on average, and it shows up in a lot of different labor markets. There are recent meta-analyses in Iowa Review, two different ones by Alan Manning and one by Ted Sorensen and a co-author. And, it's just very consistent finding across a lot of, it's more or less, but it's very consistent that employers are exercising market power over workers and paying below marginal product. And so like unions, I think we should think of as a force that's pushing against that. And I think we should think of employer market power as endemic to labor markets and unions as a countervailing force. I mean, that goes back to Galbraith and Robinson and, pushing up wages potentially towards efficient levels, pushing up employment towards efficient levels. And so it's a force that's pushing in that direction potentially against the employer market power. But, unions some are stronger, some are weaker. They're stronger in certain conditions than in others, in certain policy regimes than in others. So it shouldn't be a get out of jail free card or something like that. It should be considered as one factor in the equation, and hopefully you can assess the facts on the ground about how strong a role it's playing in this particular instance.
Okay.
Yeah.
So my next question is for Ioana. I want to go to the text of guideline 11. I mean, might as well bring the text out, right? And it reads, where a merger between employers may substantially lessen competition for workers, that reduction in labor market competition may lower wages or slow wage growth, worsen benefits or working conditions, or result in other degradations of workplace quality. And that's it. I'm just wondering, can you give us some more specific examples of how a merger might degrade workplace quality? And what should we be looking for? And finally, would you counsel the agencies to stop a merger solely on the basis of workplace quality degradations? In other words, I think I'm channeling my inner John Newman here. Are quality harms and also harm in antitrust, or can they stand on their own?
So, here I'm gonna repeat the very important principle that labor markets are a market like the other markets in the guidelines. And in the guidelines, we keep saying price and quality and innovation, right? So it's no different. It's wage and quality and innovation to the degree that you can, in fact, innovate on job design. So, so in that sense, clearly quality should matter. It's an important dimension that you should consider in terms of job quality. And when you look at impacts of a merger, and this could take many aspects. We talked about earlier, Aaron mentioned flexibility on the job, for example, is something that now that workers have fewer options, it could be reduced or taken away. And I think it's quite relevant today. There's a lot of hybrid work, and to the degree that workers like that, and then after a merger, workers have fewer options, one of the things that employers could do is to reduce the availability of hybrid work. Let's say that's just one potential example. And if we saw, let's say in documents, and that brings us back to what evidence counts, that this was a definite plan that they were intending to do, that would be, one element in the evidence that this merger plausibly, will lead to harm for workers. And this is just one example among many that one could consider. And, the agencies are going to do, like for product markets, work on the ground, interviewing stakeholders to understand what matters to workers. Because we have to remember that here, it's all about, from the workers' point of view, what is the substitutability of jobs and what matters about jobs from the workers' perspective. So we have to find out, concretely, what is it that workers care about? And I can tell you from the economics literature, it's definitely not just wages. In fact, wages have, probably not the largest role in job satisfaction. Important, but definitely not the only.
Just to be concrete, give me some examples, if you could, about measures or metrics of workplace quality. I mean, I can offer one, like hours worked or time off. What are the things that you would look for to build up a case on quality harms?
As I said, example of hybrid, but we also talked about, we have this HSR proposed changes in HSR rules where companies are required as part of their filing for mergers to disclose violations of, workers' rights, but in particular health and safety. So, for example, and so that's another example that if we know that after the merger, because there is less competition, employers are scrimping in investments in worker safety, and it can be costly depending on the context. That would be another example, right? So if we can reasonably predict that that's going to happen, That would be another example.
And would you counsel the agency to bring a case solely on a quality degradation that came about from a merger?
If the facts are there, yes, definitely. But again, it's always a fact-specific inquiry. And like similar to a product market, we'd have to look into, how the whole story lines up. And if we can make our case that it's plausible that this would, happen as a result of the merger.
Eric, did you want to weigh in?
Yeah, and this is a good illustration of a difference between labor markets and product markets, which is that according to many economists, labor markets are characterized by downward nominal wage rigidity, meaning that when costs go up for employers, or if demand goes down for their product, in the product market, they might lower prices, but they tend not to lower wages for workers, but instead fire, a portion of their workers. Now, if that's the case, when a merger occurs, and it's done precisely to obtain market power over workers, the employer might be reluctant actually to exploit that market power by reducing wages. And there are theories for why. I think there are a number of theories for why a downward nominal wage rigidity exists. For example, it has morale effects and so forth. And so if they're limited in that way, then they're going to have a stronger incentive to exploit their market power by reducing the quality of the work that is saving costs and providing amenities to workers. And an example of this, an anecdote from lawyers I've spoken to who've been watching hospital mergers. They've been so these are workers. These are lawyers who are thinking about bringing cases, and they've been interviewing doctors and nurses and other employees of hospitals after they merge. And according to these lawyers, wages do not go down immediately after the merger, but the workers do become extremely unhappy because what happens is many more tasks and obligations are imposed on them. So, for example, nurses will be required to serve, more beds than they had in the past, or doctors will have less shift flexibility, for example. So the quality of life will decline, and this provides savings for the firm, which is translated into profits. But you don't actually see a reduction in wages, but the harm is the same.
Go ahead, Aaron.
Yeah, this is, I think, echoes the point I was making earlier, that jobs are just really complex objects with a lot of dimensions. And, you can never write a complete contract because there's just too much and much less enforce it. It's much easier for the boss to take nibbles away of value from workers because you're in an ongoing relationship. There's these switching costs. And yeah, wages are very salient, but there's a million margins that a boss can take back value. Free meals, staffing levels, which dictate pace, speeding up the assembly line, right? Like understaffing, so that you're juggling more customers, like turning down the heat, turning down the air conditioning. Like there's a million margins.
Let me also say that in some markets, the minimum wage is binding. So you couldn't reduce the wage because they already paid the minimum wage. And that's where, a potential degradation in quality might be the way that market always exist.
Great. All right, the next one is Eric. I was going to ask you, but is it okay if I go to Nancy because she hasn't spoken in a while and I miss her voice. Nancy, in guideline 11, it says the features of the labor markets may in some cases put firms in dominant positions. To assess this dominance in labor markets, the agencies often examine the merging firm's power to cut or freeze wages, exercise increased leverage in negotiation with workers, or generally degrade benefits and working conditions without prompting workers to quit, end quote. Now, these sound to me or to someone in the business what we call direct evidence of a firm's market power, buying power. My question for you is, given how difficult it is to establish market power indirectly via defining a relevant labor market, particularly in cases involving labor harms, would the guidelines be better just to come out and say that in the presence of direct evidence of buying power, there is no need to define a relevant market?
I feel like that's a question for a lawyer, not an economist, but that won't stop me from at least weighing in with some thoughts. So, so one of the, I think one of the contributions the 2010 guidelines made, and that is, preserved and in some places expanded in these 23 revisions, is to continue to kind of hit on this point that direct evidence of competitive effects can be the most informative evidence on a reduction of competition post-merger. So I think we should embrace that wherever it is. The way you phrased at that kind of the end of this, which is, so, should they just say direct evidence trumps everything else, and if you've got it, you don't have to define a relevant market? Like, my understanding is that since the the Clayton Act talks about harm in relevant markets, that might not be the most successful strategy. Will it help you in establishing that these firms compete and are able to reduce competition post merger? Seems likely. If you don't have to rely as much on a structural presumption in a labor case, maybe you're able to do I think the guidelines are doing this in the product market case as well, right? Trying to do this kind of, I don't know if Susan said fuzzy market definition, or somebody said fuzzy market definition, right? Which is, thinking more like brown shoe factors instead of hypothetical monopolist test. And so I think you probably still have to do something along those lines to establish that these firms actually compete in a labor market. But then it would seem to me that what the guidelines are trying to urge courts to do is to accept this direct evidence of competitive effects without going into quite as much debate over the means and bounds of that market.
Eric, as our lawyer on the panel, or a law prof, is that true that the law compels defining a relevant market?
No, it doesn't. I mean, unilateral effects analysis doesn't require market definitions, and you could use unilateral effects analysis in a labor market case as well.
Yeah. Sorry, I looked down on my.
Unilateral effects, you would want to look at, to what extent the firms hire from each other, and so that's going to be an interesting new, empirical inquiry when we're looking at.
Yeah, I've got to say, I thought of that though as and maybe I'm wrong, but I thought of that as though establishing that if the intensity of that competition was enough, in theory, you could define these two firms as the relevant market. But if you were just saying they hire from one another and you didn't take that next step of showing that if they tried to raise price or reduce wages, they would lose so much to other firms that would make that unprofitable, that would defeat your internal analysis.
Yeah, I guess I'm not sure where the merger guidelines are going to take us.
My next question is for Eric. I'll circle back now. And here's another hypothetical. An acquiring firm has a history of labor violations. How should these violations factor, if at all, into a merger analysis? Should it inform the party's market power, as only firms with buying power could get away with such bad acts? Or should it inform anti-competitive effects? And if a firm has been found guilty of violating a labor law statute, does the act of taking those violations into consideration at the merger phase constitute a form of double jeopardy?
Right. So by labor violations, I assume you mean violations of the National Labor Relations Act, union-related violations rather than health and safety type violations.
Oh, I think it might be broader than that. I think it'd just be any violation of labor law.
Well, let's take anti-union activity. If a firm has a history of engaging in anti-union activity, we can be pretty sure it has labor market power. Presumably that's why the workers are organizing. And if the employer is breaking the law to try to prevent the workers from organizing or to undermine the union, then presumably there's a lot at stake. So that seems like good evidence about labor market power. It'd have to be translated into something more concrete, maybe, to actually stop the merger. But whereas health and safety violations, you could imagine those occurring in a competitive labor market, just because they can get away with it, I suppose. So I don't think that would be by itself. I don't think those types of violations would be relevant to a merger challenge, but maybe there's a sense in which they could be. I'd have to think about it. For the anti-competitive effect issue, I mean, if there's a union, and this goes back to Aaron's discussion of unions. I mean, one thing is that a union could be a countervailing force. So the guidelines do recognize countervailing buyers in product market cases. So I assume, do they recognize countervailing sellers? They could, if the workers unionize and have enough power, and if the acquiring firm has a history of undermining unions, then presumably there's less countervailing power in that setting. So it seems to me, that could be relevant. But there's a very interesting interaction between labor law and antitrust law. I think they have to be kept separate. They're in the sense that they're different bodies of law, but they approach the problem of employer market power in somewhat different ways that are a little bit in tension. But and this brings me to the double jeopardy question. I mean, technically, double jeopardy just means being convicted of the same crime, which is not the issue here. But you don't want to just create I don't think you want to just make blocking a merger a kind of a generic remedy for labor market violations of various types. But labor market violations do give you information about market power and other factors that are relevant for doing the merger analysis.
Okay. Anybody else want to weigh in on the labor market violations, what they mean?
I mean, I think it's not straightforward to interpret it. I don't think we have a lot of evidence. I think it's an important area to do research on. But by the same arguments we were discussing before, I think it is relevant. If an employer is, degrading working conditions so much as to make them unsafe, and and breaking the law and doing that, and they're fine, and that's some indication that the workers don't have a good exit option. They don't have a good, there's not robust competition in that labor market. And so, that should be relevant evidence. I don't know if it's like dispositive. I'm not sure how to interpret it exactly, but it certainly seems relevant. Two similarly situated, situations, one where there's a lot of evidence of labor rights violations and one where there's not, it would provide information.
Yeah, I guess. I mean, I suppose you could imagine if the labor standards are provide more safety than workers actually would demand in a competitive market, the meaning of the violations is ambiguous in that sense. But I think you're probably right as a general.
But the lesson that Eric's telling us, I think, is that just because a firm like the dollar store is in the news every other week for violating labor standards doesn't mean we should assume that the dollar store has any kind of special power over its workers. Sorry, I just offended all the dollar store fans out there. We probably just jeopardized our funding for next year.
I think so. Sorry, I just wanted to interject here to talk about the literature in labor economics about wages and amenities. So what we find is that usually higher wage firms also have better amenities, which means the absence of violations, better working conditions, etc. And basically what that suggests is that those quality dimensions are very much similar to a wage. So basically, usually they go hand in hand. Firms that can pay higher wages also choose in equilibrium to provide, higher quality amenities. So, and conversely, if you want to suppress, you'd probably suppress both at the same time, wages and amenities.
All right. Now this question's back to you, Ioana. Appendix 3B8 deals with market definition for input markets and labor markets. I promise this question gets better. There's a single line that deals with geographic market definition, and it reads, quote, geographic market definition may involve considering workers' willingness to, or ability to commute, including the availability of public transportation, end quote. That's it. That's all it says about geographic markets for labor. Can you say a little more about how a plaintiff should consider choosing the relevant geographic market for, say, a hypothetical merger between two motorcycle makers affecting highly specialized workers?
So the general principles again are, so that's what we say specifically about labor, but we have to all remind ourselves that what we say above, I think, about geographic market definition for product markets applies. Okay, so that it's like, how do we apply it to labor? And, you know, as usual, it's very fact specific, but let me just say that the one way you can go about this is to use something like a hypothetical monopsonist test and ask yourself about the importance of distance. And you know, the research certainly shows, my own research, for example, that most workers apply to jobs within their commuting zone. As an example, like 80% or so of applications on average are sent within the commuting zone. And also that secondly, you know, a commuting zone by occupation at the 6-digit level is typically would pass the hypothetical monopsonist test. Again, you'll have to look at it in the specific case that's under consideration. But those are ways that we can know that generally distance really matters for workers. Like it's an important dimension of job differentiation, of their ability to substitute. If there was, you know, a downward pressure on wages, where are they going to go? Well, it matters to know how far away other potential jobs are from the work. And therefore, you know, this emphasis on thinking about transportation costs, which by the way, is very common in product markets. When we do a product market that is, you know, driven by trucks or trains or whatever it is, we count that in when we define a geographic market. So in that sense, it's the usual, I would say, to a large extent.
Could I just weigh in on
Sure.
that? So I think it's important, you know, we're thinking in a lot of this discussion, I feel as though we're thinking about workers who are in relatively low skill occupations where we're taking their location as given and thinking about distance to employers. But I think that in some of these labor market mergers that might affect labor markets, we could have a national or even a global labor market. And so I don't think the guidelines, they don't do this. I don't think they should too much cabin in this geography. You know, so I think, for example, the Silicon Valley no poach case, right? That's a clear, I think anytime you've got a no poach agreement, it's a clear indication that the employers think that they compete for workers and that they have market power. And yet that was not, you know, does it take 20 minutes to get to either Google or Apple or whoever? And in fact, some of those locations were not even properly in Silicon Valley. Another example I would give is the railway equipment manufacturers no poach case, the Wabtec Favely. Incidentally, this conspiracy came up in the context of a merger investigation, and Knorr, who had this agreement for relatively high level engineers. Again, this sense that these companies weren't geographically co-located. You know, one was specializing in Europe, the other two kind of one US and the other kind of spanned. And yet, again, it was worthwhile to them to have a no poach agreement, not to go after each other's engineers, again, suggesting that the geographic market was pretty broad. On the other hand, sometimes when you think the market might be broad, these no poach agreements seem to be narrow. So I think about the Duke UNC med school case, right, where they weren't agreeing not to poach med school faculty from, you know, a broad set of what we might think of as med school competitors. It was this, you know, North Carolina kind of geography. So I think it has to be very kind of facts and circumstances and understanding how workers in a particular occupation, you know, are they willing to move either for their first job, which might then pin them down, or, you know, for subsequent jobs.
That's right. That's great. Hey, Ioana, economics professors would be willing to go outside their commuting zone, right? All right, here's a question for Eric. There are certain, I'm looking for a principle here that's going to distinguish good mergers from bad mergers. Let me try this out on you. There's certain merger effects in labor markets that seem to be more problematic than others. I want you to consider a merger of two economic consulting firms. I don't know where I get this, that allows the combined firm to shed one of the two HR departments. Now consider another merger of streaming services that allows the combined firm to hire fewer actors and pay the remaining actors a lower wage. Both result in less employment, but the latter seems more problematic. And it can't be just because we care more about actors than HR personnel. They're all good people. What's the principal basis for distinguishing between these two mergers?
So, yeah, it's not the identity of the workers or, you know, how much we admire their work or anything like that, or even how much they're paid. And employment loss of employment after a merger is not necessarily a reason to block the merger, just as in the case of a merger that affects product markets, the fact that the merged firm produces less of a good may not be a reason to block that merger. In both cases, you want to, first of all, think about market power. So if the firms have very little market power and they merge and they shed some of their workers, it may not matter that much because there will be other competing firms that will hire those workers who will take up the slack. So there may be, whatever the reason is for the merger, if these firms don't have market power in the labor market, this is not going to cause harm. And in addition, there might be, if there's an efficiency reason or whatever for the merger, it's possible that for example, or let's put it this way: suppose the merger is caused by a change in consumer demand for the firm's products, so they're just not going to produce as much of their goods, so they don't need as many employees. Their marginal employees are no longer producing value greater than the cost of employing them. That's just the way the market works, and the fact that a merger happens to occur at the same time is not a strike against the merger. So you just do the same analysis on labor markets as you do for product markets. You look at the market power of the firms, and if it's high, I would stop there. Economists, I think, tend to want to look at whether the merger would cause wages to go down, and that could result in employment going down as well. In which case, the merger should be blocked.
Anybody want to weigh in on that one before I move to the next one? Okay, this one's for Nancy, and I'm down to my last two. And if there's time permitting, I'd like to go to audience. If you guys, does anybody have thinking about any questions? Great. Okay, if you could hold them for two. I'm down to my last two. I promise. I'll make it very quick. But this is for Nancy, but really for anyone. Let me start off. How do you go about proving prospective harms to a worker from a merger? And so we've got a template from the recent successfully litigated book publisher merger, where the DOJ's economists there used diversion ratios to see where the authors would go in response to it, and one advance to another, and then he used an auction model to see when Simon & Schuster and Penguin were 1 and 2, how far would the advance fall if you went down to the third highest bidder. I think it was a lovely model and obviously won the day, and kudos to him for coming up with that. But is that a template for future labor effects of mergers? And if not, seems pretty specific to me. What's an economist to do to try to make the case?
So certainly if you've got a labor market that operates the way the top selling authors' book advances operate, you use, I think, those kinds of tools and approaches. You've got the data on that, and as you said, it seemed to have been a very compelling analysis. But I don't think that that's probably what you've got either in the way that most labor markets work, or the kinds of data that you would have available, or the way that workers are moving from firm to firm. I wanted to raise one thing that in response to, I think, something that Aaron said, but that's been said a lot on this panel. And that is, this notion that workers are super, super, super sticky with respect to their current employers kind of cuts both ways in a merger analysis, right? Because if workers are so sticky that each firm is a monopolist with respect to their current employees, like the merger doesn't reduce competition, and we might not be able to bring a labor market case, even if we're worried about that. Because there might not be a merger specific effect. So I think what we're going to tend to want to look at is markets where there are kind of flows of workers across employers, and we could still get the same kind of diversion data. It just we wouldn't use an auction model. I don't think we would look at, if there's some ideally exogenous variation or some movement where one employer is out of sync with the other in terms of wage changes.
Or maybe prior consolidation in the industry.
We could definitely have natural experiments like that could be terrific. And I think, that's, if you think about some of the work that like David Arnold has done, or the Prager and Schmidt hospital study, it's kind of looking at those types of effects. If you've got prior consolidations in markets, that could be terrific evidence, I would think, for DOJ to bring.
Okay, and this is my last question, promise. This is for Erin. We just mentioned the Prager and Schmidt piece on hospitals. She stole that one from you. But after that, if you were to send some researchers out into the literature to find out what have economists had to say about labor effects from mergers, where would you send them, including your own work?
Well, from mergers, I think you've just like exhausted the whole list basically with those two. But I think there's a lot of relevant evidence beyond mergers per se. So, there's no poach collusive agreements, no hire, no recruit agreements. Matthew Gibson did a study of what happened after the Silicon Valley, the high tech case fell apart, that collusion case fell apart, and found found positive effects on wages, indicating that the collusion was suppressing wages. Steinbaum and Kalachi and co-authors looked at what happened after the Washington State Attorney General stopped fast food franchises from enforcing a no poach, and found very similar evidence. And then there's a big literature on non-compete agreements in labor markets where this is just like a very straightforward way that employer takes away outside options from workers. And Evan Starr has done a lot of this work and has found, again, like the effects in a lot of these papers are close to 5%, but not quite, but we're seeing those kind of things. I also have a paper on common ownership and the effects in labor markets with Jose Azar and UAQ. We have a paper about labor market concentration as well, where we find negative effects from sort of increases in concentration on the common ownership. We're using like S&P 500 entry events and then mapping to local labor markets and looking at what happens to the wages or the earnings and employment of other S&P incumbents who are now coming into greater common ownership with one of their local labor market competitors. And we find negative effects on wages there, although positive effects on employment. So it's a little bit of a puzzle.
Okay.
And so I don't know, those are some of the, and I also mentioned earlier these good review articles by meta-analysis or review by Manning and Sorensen. And I'm looking forward to reading Ioana's reviews. I think they're going to be really important for the field. I mean, in general, I think I'm super excited. I'm a labor economist. This is like my first antitrust conference. I don't know anything. Eric is teaching me a lot through conversation about, I read his book this past month. And so I learned a lot from that, but I think what I'm really excited about in labor economics is this growing interaction with IO, because I think employer market power is endemic in labor markets, and labor economists have a certain set of tools to think about that, but IO economists have a really great toolkit. And then there's the lawyers and the policy and side. So there's a lot of exciting, we know a lot and we can learn a lot from each other. And I'm happy to point you all to evidence if you're looking for such things. Just email me. But I'm really excited about what we learn going forward, because we're really just very early in this research agenda. And labor market is really complicated. It's not like yogurt or airlines. It's closer to getting married. It's like you really care. Both sides really care about every aspect of the counterparty. And it's a really complex matching process. And, you know, I think a lot of our, so I don't know, I do want to say it's different, but I want to respect that it's the same. So I'm learning my way here. I don't know.
All right, let's go to the audience, and I see 4 hands, 5 hands. This is great. All I can say is that, you know, in the spirit of World Series starting tonight, what you just got were a bunch of softballs. Whatever comes out of the audience, I can't be responsible for. There might be some high heat. All right, let's. Yeah.
If two firms merge, there are cost reductions for like efficiency and there are frictions in the labor market. So 1% of the workforce gets laid off, 2% or 2%. They get laid off for an average of 4 months, 6 months, 8 months before they find another job. How are we going to measure these costs to workers, and do we have to, and weigh them against other things? In some sense, it's maybe not a matter of does the firm have market power or does it not have power. Probably in the labor market, all firms have some market. So how do we handle this this question of the magnitude of effects and what magnitudes are important and what magnitudes
Can I?
Yeah,
The simplest case scenario is through HHI. Define the market and do your HHI, the end. I mean, again, this is simple-minded, but that's one way.
So can let me make sure I understand your question. I understood your question to be not that they're laying off workers because of any reduction in competition in the labor market between these two firms, but more what Eric was discussing is, you know, we're reorganizing, and that's going to involve, you know, maybe I've got a technology that's super automated and I'm rolling that out to my target firm that is high labor. And I don't think that's personally, many of you may disagree, I do not think that's an actionable antitrust harm if it is not resulting from a reduction in competition in the labor market between these two companies, nor do I think it should be. Like the goal of antitrust should not be to impede the kind of continuing evolution of more efficient production, if that's what's going on. It should be to avoid reducing competition in markets. That's my view. Now, I know that's controversial, especially in this group, but no, but antitrust is not economists. Antitrust is one tool. And if Congress is concerned about those aspects of it, Congress should think about policies that address that. But economists can be concerned about all kinds of aspects, but they can't come tell the antitrust enforcers, in my opinion, that they have to act on this. I just don't think it's in the purview of the enforcement agency.
Yeah, let me jump in. This is actually a great question that it's bothered me for a long time. I wrote a paper about this in a different context of regulation. So, like, if you think about environmental regulation, and environmental regulation, you know, a regulation will be that like reduces pollution. Traditionally, you know, you look at the costs, which are for the factory building a new, you know, some new facility to reduce pollution, and the benefits, which is to people who don't have to inhale the pollution, so their health benefits and so forth. And that's it. And then people have started saying, well, what if the regulation causes people to lose their jobs? And the tradition in economics was to ignore that because the assumption was that labor markets were competitive. And so people would just get other jobs. And so there was no loss. But the economic, there is in the labor economics literature also a lot of work, fairly recent, maybe going back 10 years, showing that actually when people lose jobs, and you mentioned the Evan Rose paper, but even before that, it's much more general. They actually lose a ton, like they suffer mental health problems, their family, they break, you know, their family, there's family and cost to their family and to the community and so forth. And economists have tried to estimate those costs, and then it comes up to hundreds of thousands of, if you try to monetize it, hundreds of thousands of dollars, which raises the question for the regulation whether that amount should be put into the calculus, because regulation is not as constrained as antitrust law is. Of course, that would mean we'd have less regulation, just to be clear. Now, the thing about antitrust law is that the courts have already confined it in a way, the courts say quite clearly, the Supreme Court, we don't want this kind of broad social welfare analysis because we don't think Congress intended that when they passed this law, and we don't think courts can handle it. But it's still a fair question. You could say, you could just ask the question, the policy question, whether antitrust law should be turned into a kind of broader social welfare analysis. The worry is that you could say that about any kind of law, and I like to tease some of my colleagues by saying that there's just one law. It's maximize social welfare. We can all go home. But the way the law actually works is that it sort of narrows things down to make things more.
Rebecca, you wanted to ask a question? Oh,
Yeah, so Nancy sort of started to address this towards the end, but I was pretty convinced through your presentation that actually the correct market definition here is one firm. And that's the way that labor law looks, right? It says that this company is a monopsonist, and therefore that kind of market power needs to have a countervailing power by virtue of unionization. And you're sticking this discussion about how people don't switch jobs had me worried about precisely that problem, which is you kind of have to think that substitution works to think that there's any kind of antitrust problem whatsoever. So I guess it's a long way of asking, how do we do market definition? And I wonder if Eric's concern about the 1800 is actually a concern about market definition. That if we had a way of thinking about markets that was parallel really to the product market, then 1800 would be fine. But wanting to reduce it is actually anxiety about this question of how are we going to define markets? And if the answer is hypothetical monopsonist, I just want to preview that I'm skeptical that we'll ever find data about how you lower the wage by $1 in this way. For the reasons you got identified, which is there's so many variables and so many different things that we don't have the kind of data about a $1 investment. So how do you define markets there?
So let me say most companies are not monopsonists. And how do I know this? Because if you look at the average labor supply elasticity to the firm from some of the most convincing studies is about 4 or 5. And that it should be like 0. If it was a literal monopsonist, there's no other choice. So again, that doesn't mean in a particular case, a firm could be a monopsonist. I'm saying on average, that's not the case. There is some option out there that workers are considering. If I'm considering firm A, there are some other firms that I might be considering, which means that if firm A pays less, or offers, worse package, I'm going to go elsewhere. So on average, there is some competition, but it's not perfect competition because perfect competition would be infinite elasticity of labor supply, but it's 4 or 5, a lot of the, best recent estimates. Labor supply elasticity to the firm, which means supply elasticity to the firm. Sorry, this is a very technical term, but it means when a firm increases the wage, how much more workers does it get? And it's if it were perfect competition, it would get all of the workers because everybody goes to the highest paying firm. And if it was no competition, they get nobody because everybody's stuck in place. So it's somewhere in between.
Anybody else want to weigh in on the market definition thing? George, do you want to ask a question?
Sure. So this is kind of a variation on a question that's already been touched on, but leaving aside the broader question about whether efficiencies belong in merger analysis at all, do the guidelines or should the guidelines now vary the notion that merging parties can cite the reduction of duplicative jobs in the merged firm as an efficiency that they can use to justify the merger?
No, I don't think. I mean, they have to. I mean, it depends what you mean. They have to, like the traditional type of efficiency would be an economies of scale, and so that could be that when you combine the firms, certain facilities are no longer needed. The result of which would be that your workers would become more productive rather than less productive, and their wages would go up rather than down. Now, if you're producing less, also, you may not need as many workers. And I think that would be okay. Just in the, I mean, I guess it's, I'm not sure how this works on the product market side, but if, for example, if a firm, two firms merge and they start producing product more efficiently, we tend to think that more of the product would be bought rather than less. But I suppose it's possible if they make it a higher quality product or something like that, less would be produced, and some consumers would be hurt as well. And I guess the agencies might take that into account a little bit.
I think I am skeptical of efficiencies, but I do not believe we should ban their consideration, or I don't think we can. But George, I think the easy example for me to think of is this example where I said we've got two production technologies, one that's, say, very capital intensive, but very low cost, and another that's labor intensive. And suppose the firm that has the capital intensive one is the has a patent on that. They're the only ones that use it. The firm could come to the agency and say, post-merger, we're going to roll this new technology that we have out to everybody. It's going to lower all of the costs. We're going to produce more output, but we're going to hire fewer workers because we don't need as many to produce the output. And we're going to cite that as an efficiency. And I think the guidelines would permit firms to come forward with that defense, again, whether it's credible and the agencies buy it and it meets all the other qualifications is the determination they'd have to make. But I do not think it eliminates that as a defense, as long as it's coming from something like that kind of technology and not from, we don't have to compete with the other firm for workers, and so we're paying them less.
Yeah, I think I'm thinking about the latter situation where they say, we've got two workforces now, and we're going to now be combined, so there are a lot of jobs that are essentially the same in both companies. And now we only need one of those. We used to need two HR departments. We used to need two distribution, truckers, outfits. And now,
yeah, I mean, I guess the truckers are a little more ambiguous, but the HR departments, my thought was that never qualified because it didn't reduce marginal costs. So the headquarters consolidations, DOJ would say, fine, that's nice for you. I'm glad your shareholders will benefit. That doesn't offset our concerns about the price effects, because if it doesn't reduce your marginal cost, it doesn't eliminate the competitive harm. But the distribution's kind of like what Miller Coors got through in beer, right? Was that their distribution costs were going to be less because they had 5 breweries now that could produce the refrigerated Coors beer product, and the mean distance to the consumer was going down, and refrigerated transport was high. So I think if it were coming about from labor, DOJ would think about it, but then DOJ would also think about, yeah, but are you now going to be more effectively tacitly colluding with your rivals because you've eliminated a competitor, and maybe even with the efficiency that's credible, we don't buy it.
We'll do one more question from the audience and we'll call it a session.
Don't you ever see the Section 7 case that inferred market definition just from unilateral? Likewise, it's well established under the Sherman that you can show market power through direct evidence or through market definition. But every direct evidence case I've ever seen also is a market. So I'd love to see a case that so we know who's define a market.
Yeah, no, you may well be right. I guess I may have misunderstood your question, Hal. I just thought the question was whether.
No, the question was, do you have to define a relevant market in a merger or the labor?
You don't have to use HHIs, and that's. But if you use unilateral effects, I guess I don't see conceptually why you have to define a market if you're using unilateral effects. Maybe they do anyway, but okay, well, all right.
Well, I would be going back on my word. Can we do a quick one?
Yeah, I was gonna say, in retrospective merger challenges, you can use direct effects, and I can't remember if Evanston had an alternative market definition analysis, but by and large, Evanston's opinion, which is really worth reading in terms of both as a retrospective data way that it showed how FTC systematically moved the needle. In this case, on hospital mergers, where beforehand they were relying on bad economics, and the FTC basically turned everything around by getting better economics, as well as great qualitative evidence. So Evanston would be an example where you could rely on direct effect. Now, there's nothing that says you can't do that prospectively, but then you have to have a long track record of somebody, for example, making purchases and then trying to more successfully increasing price. One could imagine maybe roll-ups, you might be able to make that kind of argument without necessarily having to define market, but certainly the would retrospectively, not prospectively.
All right, I think we're going to let that be the last word, if that's okay. Can we give our panelists a round of applause for a great panel? Since we held you here for a while, we're going to take a 15-minute break before starting the last panel. So enjoy yourself, stretch your legs, and we'll see you in a bit.